Hello everyone, this is Sudhir Kumar Dwivedi, Assistant Professor of Law. The topic for today's lecture is a review petition and its structure under the subject drafting, pleading and conveyancing. So first of all, it is important to know what is the review of the judgment. So if we see the dictionary meaning of the review is that to examine or to study again. So the review of the judgment is to examine or study again the facts and judgment of the case. If we talk like a simple layman, then we know the review means viewing again. So in the legal term, if we are viewing again the judgment, then it is said it is review. So if the court after passing the judgment is viewing against maybe of some reason or after fulfilling the certain condition or conditions, if the court is reviewing the judgment, then it is said that the court is reviewing the judgment. It will said the court has reviewed the judgment. Now, as per section 114 of the CPC, the power of review of judgment is a substantive power which has been given to the provided to the court, and this section doesn't provide any limitation and condition for review. So this is a very, you can say, inherent power of the court to review the judgment as per section 114 of the CPC, because it doesn't provide any condition. But if you see the order 47 of the Code of Civil Procedure, then we find that certain limitation and condition has been imposed in what cases the judgment can be reviewed, what will be the condition, what are the requirement has been given in order 47. So it is also important to understand what is order 47. Before going to the order 47, let's see another concept which is related with the reviewing of the judgment, that is the concept of functus officio. What it means? Functus officio, it is a Latin word which means that once the court passed any judgment after the lawful hearing, then the case cannot be reopened and the judgment is binding on the parties. A lawful hearing and trial are the essential condition for the functus officio. How the review is an exception to this maxim, because as per this maxim, once the judgment has been passed, it can't be revisited or there can't be a rehearing. But this concept of review provides that if any party is aggrieved by the judgment, then under certain circumstances, after fulfilling some condition, they can file a review petition before the court. It is also important to know that the review, as the word denoting, the review should be done by the judge who has passed the judgment. There may be some practical difficulty. Suppose a judgment has been passed by a judge and after passing the judgment he got transferred, and when you file a review petition, then as per requirement, since it will be by the judge who has passed the judgment, but after passing the judgment, if the judge has been transferred, then what will be the scenario? Though there is no written law in this regard, but as per, you can say, the various judgment are as per the precedent or practical possibility, it has been now in practice that the judge who will come next to the same office will review the judgment. So let's see what were the condition, what will be the condition for the review of the judgment. An application for review may be filed by any person if such person perceive himself as aggrieved by a decree or order which has been passed or made by any civil court, and from such decree or order an appeal is allowed, but no appeal has been filed yet at the time of the filing of the review application. So, in the cases where a decree has been passed, an appeal is allowed to against that decree, but no decree has been preferred. No appeal has been preferred. In that case, a review petition may be filed. And in cases where no appeal is allowed, then also a review petition can be filed. Now, what will be the grounds for the review? A review can be filed if there is discovery of new and important matter or evidence which, after the exercise of due diligence, was not within the knowledge of the person seeking the review, or could not be produced by him at any time when the decree was passed or order was made. And also, if some mistake or error apparent on the face of the record, then also a review petition can be filed, or any other sufficient reason. So the first reason which has been which may be the ground for the review is that there were some important evidence which could not be appreciated even after the due diligence, or even sometimes it happened it could not be presented before the court if even after with exercise of due diligence. In that case, the review petition can be filed, or if there is some apparent mistake on the face of record, which means it is very obvious that some lacuna is there in judgment, then also review petition can be filed. Or if the party is able to prove any other sufficient ground, here the discretion has been given to the court that if the court is satisfied that there is some apparent mistake or something like that, in that case also on that the court may allow for the review petition. So now question arises, what is the time limitation for the filing of the petition of review? The time limit is 30 days from the date of the judgment or order passed, and if it is against for appeal against any sentence or judgment in high court, then it shall be filed within 60 days from the order or the judgment. And against, if it is appeal against the death sentence, capital punishment, the limitation period is again the 30 days. So it vary as per the order, in which case the order or judgment has been passed, which court the order or judgment has been passed. It will depend the time limit. If it is by the lower court or the district court, then it will be 30 days. If it is by the high court, then it is the 60 days, and if it is in the capital punishment, then the time limit is 30 days. Now let's see the structure or the format of the review petition. I have taken the example of a family court where a review petition has been filed in a family court. First of all, it will be mentioned that where it has been filed, like in the court of Honorable Principal Family Judge, district whatever will be the district, Shahadra or Dwarka or Rohini, Saket, Central, New Delhi, Tisajari, whatever is the district. First then mention the district, then the state, then HMA petition means Hindu Marriage Act petition number so and so of so and so year. Then you have to mention under what order section you are filing this application or petition. Then the petition order under 47 or read with section 114 of the Code of the Civil Procedure 1908. Then you have to mention the detail of the matter, the party's detail in the matter of so and so, petitioner who is the resident, again the complete details should be given. I have already discussed this thing many times, that whenever the detail is asked, kindly provide the full detail, name, son of, resident of, wife, whatever is the status you give, kindly it is supposed to that full information should be there. Then the heading will start like that: petition for review the judgment and order dated Dated means on which date the judgment was passed against which the review petition has been filed. Then the main form or the main factual part will start, like most respectfully so with that the marriage was solemnized between the parties according to Hindu rites, and the said marriage is registered, and a copy of the registered certificate has been filed herewith, and duly attested affidavit has been filed affirming the facts and all things. Then after that you can say what was the status before the marriage, what is the status after the marriage. All details should be given, and you can also mention that the marriage has been solemnized as per the Hindu rites and culture, and the both parties are Hindu. Then you must mention these facts in the case. Okay, then after that you can mention that the in this paragraph you have to mention the state name of the children, the if any of the marriage together with their sex, date of birth, age, all means all the family detail on which may be helpful for the how you can say the reviewing of the judgment. Or you, even if it not will be helpful, then you must then also it is required, because this is the here we give the details of the prior suit against which the review has been filed. So detail of the prior suit must be explained here, must be stated here. Then you can explain the thing that the respondent has without reasonable excuse withdrawn from the society of the petitioner with effect from so and so date. And actually the example which I have taken is related with the restitution of conjugal right. Suppose application application which has been for the regular restitution of conjugal right has been not decreed in the favor of the plaintiff in previous case, then he has filed a review petition. I have taken example of that. Then the circumstances under which the respondent withdrew from the society of the petitioner must be stated, because it will be a very strong argument to review the judgment if there was something was left from the eye of the court. Then it can be mentioned that the petitioner submits that however the honorable court white order so and so date, means on which date the previous order was passed, were pleased to pass so and so order, means you have to give in short detail what order was passed, and you can also mention that the copy of the order is annexed here with this petition as well. Then you can, it should be mentioned like that being aggrieved and dissatisfied by the judgment of so and so date, the petitioner herein has filed this petition on the following amongst other grounds, which are without prejudice to and in the alternative to one another. Means after this you have to specifically mention some ground, and which can be some other ground which may be taken from the you can plaint, that may be also considered by the court, but you must specifically mention some ground. Then you will it will be like that the petitioner further submits that had the ground set out here in below been pointed out to the honorable court, the honorable court would have certainly allowed the intervention of the petition. Then you will draw the attention of the court on which point you are seeking the review, and you will essentially mention that these points, if had been taken into the consideration by the court in previous case, then the order would have of the restitution of the conjugal right has been passed. But since it could not be appreciated by the court, that's why you must focus on those points on which the restitution, means the court will review judgment, and it is quite possible that they may pass the judgment in favor. So here very specific grounds should be mentioned. Then it can be like that next para will be that the petitioner states that in light of the aforesaid facts and circumstances, and upon the grounds stated here in above, it is just and reasonable, and it would be in the interest of justice that the said order be reviewed. Then whatever you have stated, you will summarize the thing that on these grounds the order should be reviewed. After that, you can mention that the petitioner grabs leave to add, amend, alter, and or delete any of the aforesaid ground if required. Then, being a safe side, to you can put a paragraph that if any direction will come from the court, the party, the plaintiff is ready to amend any ground or to alter or delete any ground. So it will be on the safe side so that the court cannot take adverse action against the party. That's why it is good to mention these paragraph, that if ever, if any direction will come from the court, I will amend the, or I will delete the ground or add any new ground, whatever is the direction from the court. Then the petitioner states that except this, no other petition, appeal, application, or review of the said order is filed or pending either in this Honorable High Court or in any Honorable Supreme Court of India. Then it must be mentioned that no other application has been filed against this other. Now in last, then there will be prayer clause, that the language will be like that: in view of the above facts and circumstances, it is therefore most respectfully and humbly prayed that this honorable court may be pleased to review the judgment and order dated so, and further be pleased to modify it to the extent of setting aside the order, thereby grant such other and further relief as this honorable court may deem fit and proper in the circumstances of the present case be granted. So here in prayer, you can not only ask the court to review the judgment to set aside that order, but pass any other appropriate order or judgment which you were seeking in that previous case. You may claim thing that thing in this prayer as well, in this case as well. And last, there will be place, date, petitioner, again sign through whom, if it is through advocate, then the sign of the advocate also should be mentioned. And in last, there will be a verification clause, as in almost in all plaint it is verification clause is there. So verification will be like that: above named petitioner states solemn affirm that para 1, 2 and so of petition are true to the petitioner's knowledge, and para so from so and to so are true to the petitioner information received and believed to be true by him or her, whatever is the status. Then verified at place and dated, and again there will be sign of the petitioner. And in last, an affidavit of the petitioner is to be appended or should be annexed. That's all about the review petition and its structure. Thank you.